Express Series. English for Legal Professionals by Andrew Frost. Unit 4. Exercise 8.
Good morning to you in New York. I'd like to start by confirming who is present at this video conference. My name is William Field, and I'm acting on behalf of my client, Mr. Fabian Stein, the chief executive of the London-based film company Left Hand Productions.
And I'm Fiona Martinez, attorney at law, acting on behalf of my client, Jake Glover, who is the financial director of Index Films here in New York.
So, we are all in possession of the draft version of the proposed agreement. Could I suggest that we hand over to Mr. Stein and Mr. Glover?
Maybe we could start by agreeing on a sum of money here? What kind of figure did you have in mind, Mr. Stein?
Well, I was thinking of an initial down payment followed by a later payment after the release of the film. The total would be in the region of 60,000 euros.
I'm afraid my board might find that figure rather low. After all, you are asking us to waive our right to exclusivity here.
I appreciate that, Mr. Glover, but this is a low-budget film. If we agreed to a significantly higher sum, the project could quickly cease to be viable.
Well, we might be able to agree to your figure if we could participate in the film's royalties.
I don't think that will be possible, but perhaps you could accept a figure of, say, a maximum of 75,000 euros, depending on the success of the film.
You mean if your movie flops, we would get nothing?
Not quite. You would still have the down payment.
And how much did you have in mind?
I think 20,000 euros would be fair.
Let me see if I understand you here. Index Films would get a guaranteed payment of 20,000 euros. Any further payment would be limited to the balance, namely 55,000 euros, and if the film flopped, we'd get zilch.
Well, yes, but that's putting it rather negatively. I'm simply trying to suggest a framework which would give you some kind of share in the success of the film.
Now that I think about it, maybe a success-related payment would only lead to endless arguments between lawyers and accountants. Why not drop the idea and have a 40,000 euros down payment and 50,000 euros within 1 year of the release of your movie?
I could agree to the 40,000 euros down payment if we reduce the second payment to 30,000 euros.
30,000 euros isn't really high enough. I could compromise on 45,000 euros, but on the condition that we clarify the terms for the down payment.
The down payment would be conditional upon our securing the formal agreement of the publishers.
And we do already have a signed letter of intent from the publishers in this matter.
But letters of intent are, as you know, just that. They aren't necessarily legally binding. Your negotiations with the publisher could drag on for months and months, and during all this time, my client's hands would be tied. No payment, and no freedom to negotiate with other third parties.
How about setting a time limit for the down payment? Let's say 6 months following the signing of our agreement. Or the deal is off.
Well, in view of what you just said about your letter of intent, I'd have thought that 6 months was a little too long. How about 3 months?
I think I could agree to that.
So, to summarize, you would make an initial down payment of 40,000 euros within 3 months.
Not payable, of course, if we get a rejection from the publishers.
Sure. And you would pay a further 45,000 euros within 1 year of the movie's release.
I think 45,000 euros is a little high. However, I could agree to 35,000 euros.
And I think my board would be happier with 40,000 euros.
Agreed.
Fine. I'll draw up a final agreement ready for signature, and will notify you as soon as we have secured the agreement of the publishers in this matter. Thank you very much for your time, Mr. Glover and Ms. Martinez.
Unit 5. Exercise 2.
You have reached the office of Esther Suarez. I am unable to take your call at the moment. Please leave a message after the tone.
Hi there, Esther. It's Matt. I just had a look through our company's M&A documentation, and I'm sort of confused. Some of it's in Spanish, Some of it's in English, and one or two things seem to be, I don't know, some kind of post-merger documents. Do you think you could get all this into some kind of shape for me? What I'd like is a straightforward guide to the steps we have to take when trying to make an acquisition, up to the point when the whole thing enters the public domain. And I guess I need to know where all those minefields are, too. Can you do that for me, Esther? Thanks a lot. Talk to you later.
Unit 5, Exercise 9, Part 1.
Hi, Esther. Hi, Francisco. Okay, I know you've both got full schedules right now, so let's get started. Now, our solicitors in the UK have completed the due diligence process on our target company, No Frills. Can you take us through their findings, Esther?
Certainly. Well, what you have in front of you is a summary prepared by Stefan, our trainee lawyer. You can inspect the original documents in my office at any time, of course. And no unpleasant surprises, really. It's a limited company, registered in England since 2005, and is still owned by its 3 original founders. It's grown to 16 retro-style English cafes, seems to have good growth prospects. The finances are sound. There's £300,000 of fully paid-up equity, and all growth has been organic.
I'm sorry, Esther. What do you mean by organic?
I mean that the growth has financed itself. The company hasn't borrowed in order to finance expansion. So, as far as we can tell, the company has no debts, and there are no charges against it.
And what about their public health clearance certificates, disabled access to restroom facilities, staff qualifications, all that kind of thing?
No problems there either. It almost seems to be too good to be true, but...
Sorry to butt in, Esther. But what's your opinion of the current leases for many of the cafe premises? According to these findings, the company has generally gone for very short leases. Isn't it a bit overexposed?
I'm sorry, Francisco, I'm not quite with you.
I mean, when leases expire, there's often a risk that the landlord wants to negotiate a much higher rent.
I see. Well, yes, in principle, that's true, but it doesn't seem to be a risk that the solicitors choose to highlight.
Maybe not, but I think Francisco's got a point here. Surely something like this is quantifiable, isn't it? What's your opinion, Francisco?
I think it is, yes. I mean, I'm sure Esther is right, but it would be nice to know what potential additional operating costs the company might be facing.
No, I agree. Better to be safe than sorry. I can ask the solicitors to go through all the leasehold agreements again and to check commercial rents in all the relevant locations. Then Francisco and I can have a short meeting to reassess the level of risk.
And when do you think you'll be able to give me the figures?
It depends on our solicitors. I mean, it's 1 or 2 days' work at most. So we could ask them to get back to us by Thursday. Francisco? Would you have time for a meeting on Friday?
Sure. I've got appointments through most of the afternoon, but the morning's free. Shall we say 9:30? And then we can get our figures to Matt by lunchtime.
Sounds fine.
Good. Now, before we move on, I'd just like to say one more thing.
Part 2.
So, we can't yet confirm our offer price, but assuming it would be in the region of £7.5 million, what are our financing options?
Basically, there are 3 options, some of which could be combined. We can finance the acquisition out of our capital reserves. We can borrow, or we can pay the 3 current owners in the form of newly issued shares in Foodstyle.
And which option do you favor, Francisco?
I'd prefer to issue new shares to the value of £7.5 million and buy out the owners that way. The limited company continues to exist as before. There's just a change of owner, that's all. Foodstyle would be entered into the Register of Companies as the owner of 100% of the equity of No Frills.
Any views on that, Esther?
Well, it's perfectly possible, of course. But there's always the risk of upsetting existing shareholders. We have some quite important institutional shareholders, and they might worry about the impact of a new share issue on their own shareholding. And we shouldn't forget, company law stipulates that the shareholders have the right to buy newly issued shares. We would need to get a 75% vote from them in favor of waiving their right to these shares before we could offer them to the 3 owners of No Frills. Votes like this can be risky.
And bringing in loan capital?
I'm against it.
I'm not in favor either. You see, borrowing conditions are not so easy at the moment, so we might be looking at fairly unattractive rates of interest and a drain on the company's finances for the entire repayment period.
And what about taking the money out of capital reserves? I think we need the shareholders' approval here.
Absolutely. It's needed for any acquisition of a company or a stake in a company involving an obligation of more than 2 million euros. But we would avoid the complications of a share issue.
Of course, you're right, Esther. But our capital reserves amount to 10 million euros at the moment. I don't want them to become so depleted that we overexpose ourselves. After all, our recent acquisition, the bread company, isn't doing so well, and we may have to ask the shareholders to approve a release of capital from our reserves to finance investment there.
Yeah, it's as I thought. There's no easy answer here. But I think we're all agreed that No Frills represents an excellent acquisition opportunity. So why don't we now...
Unit 6, Exercise 5.
You have reached Diana Berzinski. I'm afraid I'm not available to take your call right now, but if you leave your name and number, I'll get back to you as soon as possible.
Hi, Jana. Pete Forster here. I got your email. Glad that everything checked out okay. On the risk audit issue, yeah, I see where you're coming from on this. As you say, it could be very important, so I don't have a problem with paying for legal services if all this is really going to get us somewhere. To come back to your email, you don't really go into any detail about the scope of the audit you have in mind. So, before you go ahead, can you fill me in on that? Thanks. Speak to you soon. Bye.
Unit 6, Exercise 7.
So, let's move on to the main reason for our meeting today. This risk assessment analysis you've both been working on. Jana, how do you want to proceed on this?
Well, I thought it would be interesting to hear from Fergus first, and then I can go on to set out some of the other risks we might be facing.
Fine. So, Fergus, how do things look from your point of view?
Generally good, but I did find clauses in the agreements that we should perhaps look at in more detail. I've prepared a printout of the relevant clauses, and I will try to keep things as straightforward as possible.
Well, I'm certainly grateful for that, Fergus.
Now, the first document I'd like to draw your attention to is the leasehold agreement for our offices here in London.
It's coming up for renewal soon, isn't it?
Exactly. As you can see from Clause 2.6, the lease is automatically extended by 5 years unless we specifically state in writing 12 months before the termination date that we don't want this.
But where's the problem?
I think it's Clause 5 that's the problem. You see, your rent for these premises has been rising steadily over the past 5 years in line with the Consumer Price Index, whereas typical rents for commercial and office space in this part of the city have been falling. Basically, you're probably paying about 10 to 15% too much at the moment. What's more, if this agreement is automatically extended, then Clause 5 will continue to apply for the next term of 5 years.
I see. So, what do you suggest we do?
Under no circumstances should you just allow the lease to be extended automatically. I suggest you state in writing as soon as possible that you waive your right under Clause 2.6, but that you wish to negotiate a new lease for these premises. This will give you the chance to renegotiate Clause 5 and thus save quite a lot of money. You are also holding an option on 200 square metres of office space on the second floor. Do you really need that space? I mean, you haven't needed it so far. If you renegotiate, you can get that clause removed.
Okay, that all makes sense. And the other things you noticed?
Well, I had a look at the redundancy proposals you sent, and I think it will be better to renegotiate the size of the compensation you're offering in case of redundancy. I mean, 3 months' salary for every year's service could be very expensive if you had to lay off 15 or 20 staff one day. I think, too, that any compensation proposal should specifically state that such a payment would be gross and subject to all the relevant deductions, social insurance, tax, etc.
So this 3 months thing isn't some statutory amount?
No, not at all. This is an entirely voluntary arrangement, and one that is potentially disadvantageous to you.
Fine. I can ask the HR manager to get onto that. And you found one more thing too, didn't you?
Yes, it's a clause agreed with Finwood, the Finnish timber processors you acquired at the end of last year.
But that whole acquisition has been a great success so far.
Absolutely. It's just that...
Maybe I could just come in here?
Sure, by all means.
You see, when we acquired Finwood, valuing the company was not at all easy, so we inserted this price adjustment clause. It's all about the company's liquidity, and essentially it means that we may have to pay a little extra at the beginning of next year.
How much?
It depends on some quite complex calculations, but it could be as high as 500,000 euros.
Are you suggesting that we challenge this agreement?
Not at all. The agreement is quite fair and reasonable. What I would recommend is that at the beginning of next year, when you decide on profit allocation in the company, you allocate an appropriate sum to the capital reserves in order to cover this risk.
Is that going to be possible, Jana?
Definitely. It's just going to mean less money going to the shareholders next year or being available for investment.
I can see that there's more to this risk management business than I realised. Before we discuss Jana's findings, why don't we take a short break and...
Unit 6, Exercise 10.
Thank you both for coming at such short notice. As you've probably seen in the financial press this morning, one of our major clients, Fuller's Construction Limited in the UK, has gone bankrupt. I've called this meeting to find out exactly what this means for us. Maybe you could fill us in on the legal side of things, Fergus?
Certainly. Well, I've checked the register of companies, and Fuller's Construction is listed there as being in compulsory liquidation.
Sounds bad.
I'm afraid it does. You see, the directors of the company clearly took the view that the company couldn't service its debts and couldn't be rescued. They could have filed for an administration order, but they didn't. Instead, they petitioned the court to make a winding up order.
I'm afraid you've lost me, Fergus.
Me too.
Sorry. Basically, when a company is in administration, then the administrator is trying to keep as much of the company going as possible. But when a court issues a winding up order, it appoints a liquidator whose job it is to realise the assets of the company in order to satisfy its creditors.
I see. So the whole company is going to be sold off?
Well, its assets, yes.
And how do we stand with Fuller's Construction right now, Jana?
It's not looking good, I'm afraid. They defaulted on payment on one very large order 6 months ago. Then they made another large order and we restructured the whole terms of payment. I checked our records just a few minutes ago. They were due to pay the first installment at the beginning of last month, but...
So how much are we owed?
About 1.5 million euros, I'm afraid.
Well, I suppose we will just have to register ourselves as a creditor and wait to get back, well, some of what we're owed, at least.
I'm not sure we can count on that.
You're going to have to explain that.
Basically, Form and Function is a supplier and qualifies as an unsecured creditor. Ahead of you are preferential creditors like the employees, who may be owed wages, and secured creditors, or charge holders like banks, who lent money to the company and secured the loan against the company's assets. And then there are the costs of the liquidation process itself. They too have to be paid before the unsecured creditors can be satisfied.
So, what would you advise?
Well, certainly you should register as a creditor, but if I remember the sale of goods contract for this client, title doesn't pass to the buyer until the goods have been paid for. It could be possible to get the goods back again.
Jana?
I'm not sure we would really benefit. I mean, some of the furniture is already in use. Another problem is that it was custom built to specifications of the client. We might be able to offload it for a few €100,000, but there's the damage to our brand to consider if we start selling second-hand goods at knockdown prices.
So the worst-case scenario is that we will have to take a hit of €1.5 million. Can we do that?
Well, I've been going through the figures, and I imagine that with some debt restructuring, with some cost cuts across all levels of the company, and possibly with voluntary redundancies of 20 or 30 staff, we'll be able to get through this with our core business intact.
Sounds too good to be true. Maybe you could go through the figures and then we...